let's jump in. We have a few questions here. So do I believe that the Restore, and that's a giant, congressional acronym, Patent Rights Act and the Prevail Act will rebalance the scales of patent infringement?
I don't know. Yeah, newsflash, Matt, the trademark attorney, does not know.
Well, and I'll of course give lots of disclaimers. Here at Bold, we have, I would say, a specialty within patents, and like a lot of things, as soon as you kind of get into niches, there's even more, right?
Yeah.
And so we focus, obviously, patent law. We actually don't do litigation at the moment, right? We do what's called pre-litigation infringement analysis. When it comes to actually filing cases in federal court, we use our partners because they're in court. They're used to those proceedings, litigating and settling. So
it's incredible for those, for those listening at home. It is very rare to be either a patent or trademark practitioner and be both on the registration, transactional side and the litigation side, especially if you're doing federal court litigation.
Yeah.
At our firm, occasionally we'd send cease and desist letters and do TTAB litigation, which is Trademark Trial and Appeal Board litigation, but we leave the litigation to the litigators.
Yep, absolutely.
It's too much to balance both of those.
Yeah. That said, it is important that us patent prosecutors are still aware of the law.
Yep.
Because it's true. Even though, let's say, a patent gets granted a year ago, patent laws change. Federal Circuit, Supreme Court cases get handed down that do eventually change the law in terms of the scope of rights that you have. The most recent one, of course, was the change to abstract idea and the concept of whether a software or computer implemented invention is eligible. A lot of those did, in the years following that Supreme Court case of Alice versus CLS Bank, were struck down as invalid. It's a giant, easy example, and it can happen. Now, in this case, this is sort of on the front end of the law creation. This sort of came from a case, eBay versus Microsoft, and that case was talking about a rebuttable presumption of here we go, some legalese coming in. Rebuttable presumption.
Rebuttable presumption. So who's got the onus here? Yeah. All right, here we go.
I'm gonna try to get this right. Rebuttable presumption of a what's the wording? It's a injunction. Okay, of a permanent injunction. When a court, right, when a judge says final ruling, there is infringement. Should there be a rebuttable presumption of a permanent injunction? So let's unpack that. That's the question.
I vote yes.
Well, and so that case I talked about, eBay back in 2006, put a question mark on that because it said, you know what? No, we're not going to use this old four-prong test. We're not always going to assume that. And so the problem there is that even though as a plaintiff, right, let's say the little guy wins, right, gets the win against the big guy, that you infringe my patent. No longer can they expect to have their infringer stop. For goodness sake. So what this act would do is it would restore, and is a plaintiff, is a patent owner friendly bill. So of course I'm going to be in favor of that, at least the way I read through it. But what it will do is it'll give that via the law, right? So it'll take it out of the hands of the judge and say, look, the law actually says as soon as there is a definitive judgment on infringement, the infringer must stop, must cease, absolutely stop any, making, using, selling, or importing of that claimed subject matter.
Okay.
And now it's on the defense to come up with some wild, crazy, convincing argument otherwise. So that's really what it is. And I do think that we'll work toward rebalancing the scales toward, the patent owner. That's a long-winded way of saying that. Quick note on the Prevail Act. I did dig in a little bit. It is over my head, frankly, having to do with what's called IPR, inter partes review, post-judgment at the Federal Circuit. What this is aiming at doing is basically cleaning it up. As it is now, defendants can face two separate attacks. Federal court and IPR. Honestly, and you went to law school, right? The whole concept of, the plaintiffs shouldn't get two bites at the apple, right? In general, you should try to, what's stare decisis? Nah, I'm not gonna try to quote the Latin here, but you should all be handled in one case. So it's efficient, all things handled in once, and you have a final decision.
No double jeopardy.
There it is, double jeopardy. No ability to come back and just allege the same, underlying cause of action again.
Yeah.
So that's kind of what the Frail Act does. There is sort of this gap or loophole, if you will, where they can get hit by the PTAB and federal court on basically the same subject matter.
Sure.
So I appreciate that question coming in. How do I patent a name and patches for a motorcycle club, Matt?
I've done this.
Okay. Oh, you've done this yourself?
Yeah.
Okay, we did. We talked about this already?
No, but I mean, I've trademarked, even though it's the incorrect term for it. I've trademarked a couple motorcycle clubs over the years.
Oh my gosh, let's have it. Let's have it. Bring it on.
So I mean, yes, you can. And there's a couple ways to go about it. You can either register your assuming your motorcycle club is not descriptive of the geographic location in which you guys ride and live. Yes, you can register your motorcycle club as a club, essentially, at the USPTO. The USPTO has these 45 classes of goods and services. Everything we do falls into one of those classes. There's motorcycle. Well, let me pull up the trademark ID manual, and I'll actually get you some further information. But basically, there's kind of two ways you can go about registering motorcycle clubs. One would be to register an actual club affiliate services, application. So basically, it's a club, it's a social club, right? That you can belong to and promotes its club, right? That's one way to do it. But what I've also found too is a lot of these motorcycle clubs, no matter how rough and rowdy they are, a lot of times they have a charitable side to them too, where they might have a memorial wall that they maintain, or that they raise money like the Shriners do for kids in hospitals, or the Shriner Hospital System. So a lot of times you can also register as a charitable organization, right? Raising funds for cancer awareness or, men's health, that sort of thing. So lots of ways to register these things.
On that note, so in terms of the trademark law or the process for applying for it, does it matter whether you are a for-profit or not?
No, it does not. Does not, because a for-profit company can still have a charitable mission or a charitable service that they provide.
Got it.
It can be a private, for-profit, company, organization. You can be a collective of individuals, or you could be a nonprofit. It doesn't really matter for the USPTO.
Now, I've only been through the trademark stuff with your help for Bold, but and obviously we had to show evidence that we're in commerce. How does that work for those that aren't selling anything?
Yeah, so you don't need to sell anything to have a trademark registration. So I'm thinking back to the most recent motorcycle club that I worked on. They had a memorial wall, right? So basically, if you are part of the membership, right? Part of your membership fees go to maintaining this memorial wall for riders who have died, right? Yep. Whether they're part of the club or outside of the club. And the way that they kind of also fund that is that, let's say, you got a brother who passed away as a motorcycle enthusiast, right? Maybe he died on a bike, and you'd like his memory kind of preserved somewhere. You might make a $100 donation to this motorcycle club. In exchange, they create a plaque with a picture, and they post it and maintain it basically in a park.
Yeah.
And that's kind of how they do it. Cool. But there's lots of ways you could, prove that use. So when we worked with them, we submitted both pictures from the website. So like how you could donate to your charitable giving services. And we also submitted some pictures of the wall too.
That's great.
They were both branded, obviously, with the name of their club.
Perfect. Well, thank you for that answer, man. It was awesome with the personal. Yep. So I had this idea. It sounds great. My friends and I want to patent it. Love it. We look online, but it's actually already patented, sort of. And here's the rest of the question. I'll just read it off. There's been multiple applications to patents in multiple countries, but they've all been abandoned except for in Japan, which in the status application is said to be pending since 1998. So it's been around for a long time, over 20 years. If this person has lost interest in the patent or just based on their LinkedIn career, this person's really been researching and just left it pending. Does that open it up to the market again to be patented? Great question. And I got a pretty straightforward answer here. Is
it a 2-letter answer?
No. You cannot patent something that's been out there already, unfortunately. But what's great is you can go to market with it. So you've done a heck of a job researching. It sounds like this is an important idea. I would caution you, being a patent attorney, if you think there is any additional nuance, improvement upon, what this prior invention had, anything there might be some additional novelty, something that makes this thing different above and beyond than what this other, patent that's been published in Japan for over 20 years has done. Have a talk with a patent attorney. Give us a call here at Bold. We'd be happy to chat with you. But if it's exactly on or very, very close to what's already been out there, as you've found, not a good chance of getting a patent. So I wouldn't even pursue that. But what you can be sure of is that no one else has a patent on it because it's been published already. It's an automatic defense to anyone who may allege infringement. So quick answer. Thank you for that question. It's good. One of the quick note I will say is that if you're inventing with your friends, and I wanted to mention that too, your friends and I want to patent it. Well, what's important to understand is there's a difference between inventorship and ownership. We could go on it for a bit here, but I want to make that point that if you are the sole inventor, only you should be named as the inventor. And if your friends want to basically go into business with you, right, around the technology, around the invention, well, I recommend them forming a business LLC or a C Corp and having your interests documented in a formation agreement, a contract that's binding around the ownership. And you can assign the patent that you own as the inventor to the company. That's going to be the most sophisticated way to handle that. Make sure all parties are taken care of.
Yep. Agreed. That sounds great.